Good afternoon everyone and welcome back to the subcommittee meeting for its mustard on the 4th of September. The subcommittee has considered very carefully the application for the review of the premises licence at its mustard. It gave due regard to Licensing Act 2003, the licensing objectives, statutory guidance and the adopted statement of licensing policy. The subcommittee considered the relevant representations both written and given orally at the hearing by all parties. Human rights legislation and public sector equality duty has been borne in mind when making the decision. All options were considered carefully, as well as the financial impact on the licence holder. The subcommittee determined it was appropriate, given all the circumstances, to remove the DPS at the premises and impose the following conditions. The premises licence holder shall instruct an independent noise sound consultant. The consultant, to be approved by the environmental health officer in advance. The consultant shall be instructed to advise upon measures to alleviate noise escape, the reduction of vibration to other rooms and noise transference through the structure of the premises to the adjoining nearby properties as appropriate. In addition to general advice, it shall also detail advised steps required for the implementation of soundproofing at the premises and specification for installation of acoustic lobby measures to reduce the noise escape from glazing, in particular the glazed roof to the rear of the premises, and installation of noise limiter in the premises. Live music and recorded music shall not be permitted at the premises until the measures have been implemented, as advised, to the satisfaction of environmental health. The outside area of the premises shall not remain open to patrons after 9:30 on any given night, save for the access in the toilet and emergency access. The premises licence holder shall place prominent signage at the premises to ask patrons to respect neighbours. Live and recorded music shall only be permitted at the premises on 2 days in any given week, Monday to Sunday, and shall cease at 2200 hours on any such day. Amendment of the licence to make it clear that the above conditions limiting live and recorded music have been added in accordance with 177A of the Licensing Act. The reasons for this: it was noted that the application for the review had been brought by Environmental Health due to concerns regarding noise nuisance. Noise abatement notices have been issued following the witnessing of statutory noise nuisance on the back of complaints from residents near the premises. Following the service of notice, 6 further breaches of notice statutory noise nuisance were witnessed by officers or assessed by officers to have reached that standard. 4 residents have complained to Environmental Health, although it has been noted that many of the long record of complaints originated from one household. 22 residents made representations complaining about the noise from the premises, and in support of the application, 7 representations were lodged. The Environmental Health have requested a condition to be imposed, removing the ability to provide live or recorded music, citing a frankly shocking history of non-compliance. For the premises licence holder, it was suggested that there had been a breakdown in communication with Environmental Health and that car parking disputes to the rear of the property had been the real driver for representations regarding the noise. Residents to the rear of the property are not present, and it was suggested that their representation should not be considered or should have attached less weight. The subcommittee accepted advice that those representations ought to be considered, but the appropriate weight attached given that they were not present to be challenged. One resident, however, was in attendance and outlined the impact the premises had upon her, including the impact on her mental health, that the DJ and the bottomless brunch benches have had considerable impact given music noise can be heard throughout her property. The noise prevents sleep, limits the use of her garden and even the bathroom. For the applicant, it was argued that the particular representation amounted to private rather than public nuisance. The subcommittee took legal advice during the deliberations and referred to a statutory guidance and the case of Hope and Glory, which will be referenced in your report when you receive it. On the basis that the 4 residents had complained of nuisance due to noise, the Environmental Health team and 22 objections citing noise nuisance had been received to the subcommittee. It was satisfied that there was nuisance, whilst affecting different people in greater or lesser degree, and it did amount to a public nuisance in accordance with the Act, and guidance to separate the representation of one individual would be artificial. The subcommittee considered the application request for removal of live and recorded music. However, this was not considered appropriate, given the reduction in complaints since the review proceedings have commenced. The lack of cooperation with the relative authority, irrespective of any alleged breakdown in communication, is, however, considered extremely serious. This is particularly the case given the repeated lack of response to correspondence and the continuation of statutory noise nuisances at the premises despite the service of an abatement notice. The subcommittee is well aware that its role is not to determine criminal offences. However, the fact that continued breaches are reported in circumstances outlined are of deep concern. For these reasons, the committee feels it has no option other than to remove the DPS and has strongly recommended the premises to positively engage with the Environmental Health moving forward. Whilst the premises was noted as being reluctant to limit recorded music pending the implementation of the above steps, The subcommittee was satisfied that it had no option other than to restrict both pending the implementation of the steps to limit those noise escaped. This was felt to be important to protect the residents. Whilst at first glance restrictions of 2 days per week or live recorded music provision may seem restrictive, the subcommittee were bound to consider the impact of the use of temporary event notices, TENS, at the premises, and the combination of 2 days allowance with the appropriate noise measures conditions, the TENS were felt to be an appropriate balance. It is also important to stress that background or incidental music is not licensable and not restricted by the above conditions. There is a statutory right of appeal which must be lodged with the magistrates' courts in 21 days of receipt of the formal notification of decision. Formal notification of decision shall be set out right in full.
Mr. Chairman, I don't want to get into debate. You've got your legal advisor there, but because you've received some advice during the deliberation, I think it is incumbent on me to try to avoid us getting into more protracted legal like appeals and things like that. In relation to the recorded music, and I can understand the point that you're making about live music, but recorded music, if the noise consultant, through the environmental health and the measures you've asked for, sets a noise limiter that doesn't disturb people, I just want to try to understand the rationale why you would then restrict it to 2 days. If all that work's been done and it doesn't affect neighbours, why is it now recorded music for 2 days? And I can't understand the rationale. I don't want to have to go off an appeal, but if everything is done as you've set out on recorded music and it goes through a noise limiter, then there should be no reason why it can't be done all the time. Live music is different, and I accept that, but recorded music, you would in effect, if we did all this, you would lose an appeal, and I want to avoid getting into a conflict with the council. Now, I'm happy to step outside while you get some advice, but I would rather try to bottom it out now today than go running off at the magistrates and wasting more time and effort for everyone.
Chair, I think you've heard that representation, and I would advise that you re-deliberate just on that point, just to thrash that point out.
Let's adjourn for 5 minutes. We'll return in 5 minutes' time, no longer. Thank you. Wonderful, thank you. We're returning to the subcommittee meeting on the 4th of the 9th, 2023 at 2:45 in the afternoon. I will just read the following statement. After considered representations after the reading of the decision by the subcommittee, we have accepted that the recorded music shall be removed from the 2-day restriction and that the condition amended accordingly, but for the avoidance of doubt, it remains restricted pending the implementation of the required steps. Okay? There is a statutory right of appeal, which must be lodged with the Magistrate Court within 21 days of receipt of formal notification decision. Formal notification decision shall be set out right and full. That brings the meeting to a close. Oh, yes, Lorraine?
Can I just get Ben to clarify that the recorded music includes a DJ, please? It does, yeah.
Recorded music does include a DJ. Yes, it does. Thank you very much for everyone's time today. I'll close the meeting at 2:45. Thank you very much.